current court case, Jenny versus Hoover School District, has rekindled the argument concerning the position prayer ought to hold within public schools. Melissa, a high school student in the Hoover School District, led a number of her peers in the prayer before lunch each day. This occurred for the duration of the school year. However, roughly a quarter of the students in the lunchroom did not participate. Jenny, one of these students who did not partake of the prayer, eventually sued the school district. She claimed that this student-led supplication was unconstitutional and violated the Establishment Clause. I believe Jenny's complaint is unfounded. If school prayer is student-initiated, not disruptive to the education process, and not advanced by government equipment, and not explicitly endorsed by government workers, for example, teachers or other school staff, it is perfectly acceptable. Jenny's argument is inevitably nullified by several case precedents, therefore, she has no viable dispute to carry into the court. In the case Jones versus Clear Creek ISD, student organized prayer was similarly called into question. The high school graduation ceremony in Clear Creek ISD traditionally includes an invocation spoken by a student. The student is elected by his or her peers, so the district staff cannot influence the speaker's identity nor the content of the invocation. In the spring of 1991, two families in Clear Creek ISD, known collectively as Jones, objected to the inclusion of an invocation in the high school graduation ceremony. They insisted the Establishment Clause was being flaunted by allowing a prayer within school, and they subsequently sued the school district. The Fifth Circuit Court of Appeals ruled against Jones, declaring the school prayer to be constitutionally sound. The case hinged upon the vital fact that the prayer's contents was at the discretion of the student, and it was neither monitored nor endorsed by school staff. As such, the prayer could not inherently violate the Establishment Clause. Jones versus Clear Creek ISD bears a stark similarity to Hoover School District versus Jenny. Namely, the school prayer in both cases was composed and delivered by a student, independent of school staff. School prayer infringes upon the Establishment Clause when it is authored and mandated by public school staff, who are technically government officials. The Supreme Court's case, Angel versus Fatale, clearly exemplified this principle. In 1962, a family in New Hyde Park, New York, protested against an official public school prayer. The prayer had been authorized by the New York Board of Regents, and this recitation was highly encouraged in public schools throughout the state. So the Supreme Court ruled that government-written prayers necessarily violate the Establishment Clause because they implicitly promote a particular religion. It was a landmark decision, however. A crucial distinction must be drawn between this case and Hoover School District versus Jenny. Whereas the ruling in Angel versus Fatale evolved around the principle of government-written prayer, Hoover School District versus Jenny involved student-initiated prayer. Most staff members in Hoover High School influenced the content of Melissa's lunchtime prayers. Accordingly, Melissa's prayers were wholly separate from the government control. The Supreme Court case Santa Fe ISD versus Doe raised vehement controversy over a unique aspect of school prayer. High school football games in Santa Fe ISD and a school district of Texas had long been prefaced by student-led prayers. Students were given the community to pray, the opportunity to pray over stadium's loudspeaker system, which significantly amplified the invocations. Eventually, a couple of families offended by the pregame prayers filed suit against the school district. The plaintiffs, who were allowed to be anonymously and collectively recorded as Doe, soon carried their case up to the Supreme Court. The ruling condemned the pregame prayers, chiefly due to the mode of deliverance. The fact that government equipment was utilized to amplify the invocations was considered the most grievous violation of the Establishment Clause. Nevertheless, this precedent can hardly lend validity to Jenny's case. Melissa had no amplification, therefore, it seems unlikely that Santa Fe ISD versus Doe can be used to condemn her prayers. Her prayers can be deemed unconstitutional if it disrupts the educational process. One may observe such a situation in the Supreme Court case Wallace versus Jaffrey. Prior to 1985, a particular Alabama law authorized public school teachers to devote a moment each morning to meditation and voluntary prayer to any religion. Ishmael Jaffrey, a parent of 3 students in Mobile County public school system, passionately protested against this policy. He filed suit, and the Supreme Court ultimately assumed the case. The Supreme Court ruled that Alabama statute violated the Establishment Clause. However, it was not necessarily due to any sectarian religious intentions of the law. In other words, the Alabama law did not explicitly promote a particular religion. Instead, the law was condemned for cutting into classroom time. The moment of silence was considered to interfere with education process. It seems inconceivable to apply this precedent to Hoover School District versus Jenny, because Melissa's prayers occurred outside the classroom. The lunch hour has classically been allotted to students for fellowship, and students do not receive education during this time. In summary, Jenny's argument utterly lacks bearing because her position is not supported by the court precedents. Jones versus Clear Creek ISD undoubtedly condoned student-initiated prayer as long as the student of said prayer was neither monitored nor endorsed by school staff. Hoover School District versus Jenny seemingly aligns with his stipulation, since Melissa was not pressured nor influenced by school staff. However, Hoover School District versus Jenny also remains unaffected by the ruling in Angel versus Fatale because Melissa's prayers were not associated with any sort of official school invocation. Melissa's prayers similarly evade the conflict with the ruling from Santa Fe ISD versus Doe, since she had no access to government equipment, such as a school amplification system. This was highlighted by the fact that roughly a quarter of the students in the lunchroom were able to ignore her on a daily basis, barring the plaintiff, of course, who took particular offense. Finally, Melissa's prayers do not violate the precedents set by Wallace versus Jaffrey. It seems obvious that the education process cannot be inhibited by proceedings outside the classroom during a time devoted to student communion and verbal exchange. If Hoover School District loses this suit, the repercussion would necessitate serious reform in the realm of school prayer. Of course, schools could not force students to revoke their beliefs. However, vocal prayer during school hours would be seriously limited. Were the rulings to favor Jenny, it would be difficult to draw between acceptable student-initiated prayer and that which is unacceptable. Would it only condemn large-scale prayer, as in the case of Melissa, or would it forbid even small groups of students from praying and evangelizing? If the latter were to prove true, I would be alarmed indeed. Nevertheless, I doubt the court could stretch this far. I feel religious clubs or organizations at school would still be permissible. In any event, we can rest assured that tried and true First Amendment protects citizens from exceptional religious suppression. Gee Willikers.